Intellectual property is the creation of mind. So it's a product of our mind. We are using our mind and we are creating something, and that will come under intellectual property. The intellectual property can be an invention, or you might be writing a book, or you might be doing a song, something like that. It can be a design which you have created. It can be a symbol. It can be a name. It can be an image. Anything that comes from your mind, that will come under intellectual property. And intellectual property is an intangible property. So, this is intellectual property. Before going to the protection of intellectual property will be covered in intellectual property rights. So, why should we protect our intellectual property? To tell about that, I'll be sharing with you one small example. Facebook recently got the name Meta, and they took it from a South Dakota bank, the name Meta, because the bank had already registered the name Meta, and for getting this name from the bank, Facebook had to pay around $60 million. So since this bank had registered its name Meta, to get it from them, the Facebook had to spend around $60 million for that name. So that is a power of intellectual property. Just the name Meta was registered as a trademark, and to get that, Facebook had to pay. So this is the importance of registering or protecting your intellectual property, whatever you have. So what is the benefit? It is to protect our moral and economic right. Then if you have intellectual property protected and you are getting gains out of it, it will promote more creativity. Okay, then it will encourage fair trade, and it might contribute to social and economic development of the area. So what are the various intellectual property that gets protection in India? One of them is patent. Patent is normally given for an invention. Invention can be a product, it can be a process, it can be a apparatus, anything. So patent is given for invention, and to show that electric bulb, which was invented by Thomas Alva Edison, it got patented in United States Patent Office. So patent is normally given for an invention. Now, another intellectual property is designs. Design is just nothing, the visual aspect, the design of the bottle, the shape in the bottle, all that, the shape, how the bottle is made, or various curves within the bottle, just the visual aspect. That will come under designs. Another one is trademark, which I already told about, that Meta and Facebook. Trademark. You might know the trademark, Google, all this comes under trademark. Then another intellectual property is geographical indications. Then there is copyright. Then another one is semiconductor integrated circuit layout design, SICLD. So these are the various intellectual property, and I'll be going to one by one in detail. So this is a single apparatus, and you can see that almost all the intellectual properties will be covered in this. For example, the display technology of this MacBook will be covered with patent. It will be protected with patent. The design of the laptop, that is the body of the laptop, will come under the design. The sign, the Apple sign here, that will be coming under trademark. The integrated circuit, the layout of the integrated circuit within the laptop will be covered under the SICL design. And a manual which may come with the laptop can be copyrighted. So the various intellectual properties are covered in one single product. So another example, let it be a pressure cooker. The constructional feature of the pressure cooker, say the safety valve mechanism, this will be covered within the patents. Then the design of the pressure cooker, say the lid or the body of the pressure cooker, the handle, everything will be covered under the design. Trademark, maybe Prestige or Hawkins or Butterfly or whatever, that will be covered under the trademarks. So a single product might have multiple IPs associated with it. So now we'll go to one IP in detail. The first one is patents. So patent, what is a patent? Patent is a contract between the inventor and the state, legal contract. So legal contract between the inventor and the state The state in India, it will be the government of India. And this legal contracts give the inventor an exclusive monopoly over his invention. And that will be for a limited period of time. And for getting this exclusive monopoly, he need to disclose everything about the invention in the application of patent. So patent is a contract between the state and the inventor, and as a result of this contract, the inventor is given an exclusive right or exclusive monopoly over his invention for a period of time. In India, it is 20 years. That is a limited period will be there. And for getting this, he need to give all the details about his invention. So that is a patent. So patents are normally given for a product. It is for invention. Invention can be a product. Say you get a patent for a pen, or you get a patent for a medicine, anything like that. It can be for a process. The process can be, say, for example, process of degrading lignin using micro. So the process can be process can get the patent, or it can be an apparatus, say a pressure cooker. So all this comes under inventions. And patent rights are territorial. Territorial na, that if you apply a patent and you get a patent in India, that patent rights are only constrained to India. You can't go to US and tell, okay, I have a patent in India, you can't use my invention there. If you want someone to not use your invention in US, you need to go there and get a patent. So it's territorial. It is applicable to a area. And if you get a patent in India, it is applicable in India. And if you want a patent in US, you need to go there and take a patent. And similarly, if you want in other countries, you need to go there, enter that country and get a patent there. And the patent period is 20 years. And this 20 years is that you are supposed to pay the renewal fees. Then you will get the invention protected for 20 years. You will get the exclusive monopoly for 20 years. And in patent intellectual property, it's always recommended that first, if you have an invention ready with you, you need to come and file the patent application first. After filing the patent application, you can go for the publication of that work or use of that work or sharing of that. It's always necessary that you come and file your application first. Then if you suppose you have an invention idea about an invention and you have a small prototype of that, and you think within 1 year I can complete that invention into the full working one. So you can come and file an application in the patent office with that small prototype, and you'll be given a time of 1 year to complete your invention and file the full specification. So it's always necessary that you first file your application, then you go for the publication, using or sharing, even if it is just a prototype which you have. So patent application filing. The first thing is how you will file an application. You can come with the hard copy. The hard copy can be given in the patent office, or you can go for the online filing. There is a e-portal and you can go through that and file the application. But there is something called jurisdiction. If you are doing your invention in Kerala or your inventors are from Kerala, you need to come to patent office Chennai to file your application, or you need to do it online to Chennai patent office. So this is the thing. Chennai patent office takes care of the inventions within Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, Pondicherry and Lakshadweep. So there is jurisdiction involved. So if you want to file a patent application, what are the forms you should fill and what is the fee with respect to all that? So these are the basic forms. There is a form 1. The form 1 will be dealing with the details of the application. You'll be giving the applicant's address, details of the invention, just the name of the invention, all that. So it will be just a details of the applicant will be mostly there. Then the next form is form 2. Form 2 is details of the invention. In this form 2, you'll be describing the invention in detail. You'll be giving all the important features of your invention. So that is form 2. And another important form is form 18, that is request for examination. You need to file this If you file this request for examination only, your patent application will come into examination. So these are the basic form. You have a form 1 where you'll be giving the detail of the application and the applicant. You have a form 2 where you will be sharing the invention. You'll be describing the invention in detail, and you have a form 18 for request for examination. So these are the fee, and for an educational institute or a natural person, the fee will come around 5,600. So once you file an application, you can file a complete application, or you can first file a provisional application. That is, you have a small prototype ready with you and you have 1 year time to file the complete application. You come and file the complete application in the patent office. After 18 months, this application will be published in the official journal, and after the publication, it will come to the examiner for examination. We'll be examining the invention. The basic criteria we check is novelty, whether it is new. Whatever the invention you are coming with is new. It is not there anywhere. It's not there in prior art. The next one will be whether it is inventive. If it is not new, is it having an improvement over whatever is already existing in the literature? That will be the inventive step. And whether it is industrially applicable. Is it having some utility? Simply something without any use won't be accepted. So these 3 criteria we normally check. Novelty, whether it is new. Inventive step, whether it is having any advancement over what is already there in literature. And third one will be industrial applicability. Then we'll be issuing an examination report, which will be sent to the applicant. The applicant can go through the report and he can modify his invention accordingly, or he can give his reasoning. After that, a decision will be taken whether the application should be rejected or accepted. If it is accepted, you will be given the grant certificate, and for 20 years, you will have the monopoly over the invention. So this is the basic steps that we follow here in the patent office. So this is a grant certificate. So this is patents. So we have completed the patents. Anyone having any queries? Okay, since there are no queries, I think. Yes.
Hello. Madam, how do you do this examination? We have to come there and demonstrate, or you will come to the laboratory?
There is no. You need not demonstrate anything. Whatever, we just believe whatever you have given. You'll be giving the complete disclosure of the invention. So we'll be thinking whatever you are doing is a complete disclosure, and we will be checking with respect to that. There is no need for any demo or anything like that. And demo will be required if we feel, yes, this need to be demonstrated, then we might call you and you need to give a demo. That's it.
Okay, thank you.
Any other queries? We'll be just checking the 3 things. That is novelty, whether it is new, whether it is having an inventive step, whether it's an advancement or whatever is already there in the literature, and whether it is industrially applicable, is having any utility. These 3 are the main criteria for patentability. So I think since there are no other queries, I'll go to the next intellectual property, that is designs. Designs is just an ornamental or aesthetic aspect on an article. You can see the shape of the bottle or that design within the car. It is the external feature that is appealing to the eye. We just look at via the eye and see. That's it. And it can be a new shape or a new pattern or a new configuration. If it's a 3D, it can be a shape. The shape of the bottle or the surface, the shape within the surface of the article. Or it can be the patterns, lines, or colors in the article. So it's just the external feature that is appealing to the eye, not ornamental or aesthetic aspect on an article. That will be covered within designs. So designs are given for a period of 10 years, and you can extend it up to 15 years by paying the fee. So the design, even the design within the mask can be protected by the intellectual property designs. So how do you file a design application? Design application can be filed in any of the patent office or any of the patent office via physical filing, or you can do the electronic filing. But The design applications are examined, registered, and published post-registration. All that work is done in Intellectual Property Office, Kolkata. So whatever is filed in any of the patent office will be forwarded to Kolkata, and the examiners there are given the duty of the examination of the design applications. So for filing a design application, you need to pay the application fee. Then there is a form 1 where you'll be giving the details of the applicant. Then there is you need to give 2 sets of representation illustrating the various views of the article. These are the fundamental requirements of filing a design application. So this is a design grant certificate. So if you have a design registered, you can, if you have an article registered with design IP, you can mark it with registered REGT or RD with registration number, and this will deter infringers and help you in the legal actions. So this is the intellectual property designs. Now another one is trademarks. Trademark is a word, name, symbol, or device, or it can be a combination of all this, and it will help in identifying and distinguishing the source of goods or services of one trader and the other. For example, okay, you will be able to distinguish, since that Amul trademark is there, you can distinguish that Amul butter or Amul ice cream or whatever. That is trademarks. And as I told, it can be a word, it can be a color, it can be a design, or it can be a combination of all this. See Cadbury, that font there, or the color, or that symbol there, that apple symbol, or the slogans. It can be as if McDonald's, I'm loving it, something, or it can be even sounds. That MGM pictures, when it opens, you get a lion roaring sound. So all this will be protected under trademark. So trademark will be giving you exclusive monopoly over a class of goods or service, and you, the business entity, can have a public goodwill and brand reputation, and even it helps to identify the source and origin of the goods or service. And the customer will be assured about the quality of the good or service. So if you have a trademark and if the application is pending, you just mark it with TM, and if it is registered, you mark it with the R. So trademark is initially registered for 10 years, and you can renew it. And indefinite renewal is possible, but you'll be given a 10 years, 10 years, 10 years time. So 10, 10, 10, you need to go. And the trademark registration is governed by the Trademarks Act and trademarks rules. So the other intellectual property is copyright. Copyright is an intellectual property right that is provided to the creators of literary, dramatic, musical, and artistic work. And the owner can choose how his work should be made available to public, and he can prevent the unauthorized copying or reproduction of his work. And another thing I want to tell you is, if you have an idea, it cannot be copyrighted. It should be fixed somewhere. There should be a medium of recording that idea. Say if you have a story with you and you tell the story cannot be copyrighted. You should record that, or you should write it in a book. Then only that intellectual property can come under copyright. So copyright is given to literary works, artistic works, dramatic works, musical works, sound recording works, cinematographic films, etc. So for the criteria to be copyrighted is creativity. Then it should be something original, and it should have a fixation. That is, it should be recorded somewhere. Say if it's a story, it should be recorded in a book or a cassette or a cassette, somewhere like that. So simply, if you have a story and you speak it out, that cannot be copyrighted. So this is, if it is a literary or dramatic work, the author will be the person who can go for the copyright. He'll be the owner of the copyright. The photograph, it is the photographer. So if you have a copyright, you get both economic rights and moral rights. The economic rights is the monetary benefits you get out of the copyright. The moral right is that nobody can use it without your permission or reproduce it without your permission. It's a non-transferable right. So if you have a copyright intellectual property and you want to come what you need to do is you need to fill that form 14, and the copyright office is in New Delhi. You can come by person or by post, or you can go for the e-filing, and you need to pay the required fees. And this is the term of protection. If it is a literary work or dramatic or artistic musical work, it is life of the author plus 60 years. And this is the fee structure for the copyright. So that is copyright. Now the last intellectual property is semiconductor integrated circuit layout design. Now it's an electronic age, and all the electronic devices will have that integrated circuits within it. So to protect that, this particular thing has come into picture, that is semiconductor integrated circuit layout design. And the registry is in New Delhi. And the term is 10 years from the date of application filing or first commercial exploitation, whichever is earlier. So this is semiconductor integrated circuit layout designs. The other intellectual property is geographical indication. Geographical indication is an indication that identifies a product that is having a specific geographical origin, and the product is having qualities or reputations because of that origin. So from that product, you will be able to know the source of the products. For example, say Aranmula Kannadi. You know that Kannadi is from Aranmula, and that is a GI. Then it indicates the unique qualities. Say Palakkad and Matta. That rice has its own quality, and you get to know it's from Palakkad. And it promotes the product with a distinguishing name, and it prevents infringement and unfair competitions. So these are all the GIs: Darjeeling tea, Rajasthani marbles, then Wayanad and Jeeragashala, all that. So I'll be just sharing one, that's Tirur Vettila. Tirur Vettila GI is normally applied by a group of people. In case of Tirur Vettila, the Tirur Vettila Ulpadaka Sangam came and applied for the GI. And this betel leaf is grown in the Malappuram Tirur area, and because of the soil and climatic conditions there, this particular leaf has high chlorophyll, high protein content, high eugenol content, and because of all this, it's having its own pungency. So it's something unique, and all this is because of the area where it is grown. So this got a GI. So other GIs, you might be knowing all this: Darjeeling tea, Markhana marble, Rajasthani one, Kanchipuram silk, and all this. Then in Kashmiri saffron, all this will come under GI. So validity of various intellectual properties like that. If it's a patent, it's 20 years, and there is nothing called global or international patent. It's territorial. If you want a protection in India, you need to come and file here. If you want it in some other country, you need to go there and file your patent application. Once filing in one country doesn't guarantee that your invention will be protected in all countries. Then design, it is for 10 years, and you can renew it for another 5 years. Trademark is indefinite renewal, and it will be given for 10 years. GI, it is indefinite, but initially it's given for 10 years. And copyright, if it is a literary work or an artistic work or musical work, it would be the lifetime of the author plus 60 years. So intellectual properties, all these can be, protection for these can be applied by a person or his or her legal representative. In the case of GI, it is a partnership. In case of GI, it is not an individual, it will be a group of people. And all the IP rights, whatever I talked here, patents, designs, trademarks, GI, copyright, it's territorial. It's just valid in India. If you have taken the protection in India, it's valid in India. And points to remember is, as I told, first protect, then publish. The next one, its rights are territorial and limited to the boundary of the country or the authority. And registration is required for each and every country. And the registration in a country is done by the sovereign authority within the country. In India, it is Government of India. If you go to US, it will be the US government. And it's for a limited period of time. Say I told already, for patent, it's 20 years. And there is no automatic relief. That is, if you have an invention, you patented your invention, and you get to know someone is using your invention without your permission. If you don't go for infringement suit, Government of India won't interfere. You need to file for your relief. That is, you need to file the infringement suit if someone is using your invention without your permission. Then for all the intellectual property, you need to pay the renewal fees. Then normally for patents, people come via patent agent, but patent agent is always not necessary. You can yourself sign the documents and file yourself. So I have discussed all the intellectual properties, and I'll be just telling some of the career opportunity that can be in this field. If you are going for a government sector, these three posts are there: examiner of patents and designs, examiners of trademark and GI, examiner of copyright. For examiners of patent and designs, you need to be a postgraduate in science, or if you are from an engineering discipline, you need to be a graduate. And for examiner of trademark and GI and copyright, you need to have a law degree. So these are the openings in the government sector. And in private, you can work as a patent agent. Patent agent is someone who will help applicant in filing the patent application. To become a patent agent, you need to write an exam that is conducted by the government of India, and you need to pass that and secure your agent ID, and then you can help others in filing your patent application. Similarly, there is trademark agent, or there are patent facilitation centers in private as well as in research institutions nowadays. You can be a JRF or SRF in these facilitation centers and help the institute in protecting their IPs. So this is our training institute, that is Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. In case you want further training or something, you can contact them. They normally provide trainings. So I'll show you, if you have an invention with you, if you have some intellectual property or patent, something invention with you, you can contact these people. They will help you. Kerala State Council for Science, Technology and Environment, they have their IPRICK, and they normally conduct awareness programs, and they help you file your patent applications, all that. Then there is a scheme called as Kapila. That is a scheme that provides financial assistance to institutions that are a part of higher education institutions for filing patents. There is a scheme. And then there is the Department of Science and Technology. They have their own facilitating center, and they normally create awareness and help you in this intellectual property things, especially patents. Then there is NRDC, National Research Development Corporation, and they also have all these consultancy services, all that. So that is it. Now I have any queries? So I have dealt with intellectual property, patents, designs, trademarks, GI, and SICLT, copyrights. And I have just shown you what are the career opportunities you can have in this field. And these are some of the people who can help you if you have a patent or any intellectual property ready with you in filing and assisting you in filing all this. So since there are no queries, there is a small quiz, and I want you all to participate in that.
Ma'am, I have a query.
Yes, ma'am.
This is regarding the Women Scientist scheme. There is something for the PG students, right? Some scheme.
Yes.
Can you just tell about the scheme?
The scheme is actually for women scientists, and if you have a break in your career period, normally they encourage such people. They will be giving them the training in the patent, the intellectual properties, especially patents. Okay, and they will be helping you to prepare for that patent agent exam. Okay, so you can, after that, it is actually what I can tell. They'll be conducting a course for you, a small course for you, and after completing that course, you can write that patent agent exam, and you can become a patent agent, and you can help others in filing the patent applications, all that. And during the training period, they give you stipend, all that. They'll be training you in this patent acts. And that training period, you get your stipend and you get trained. After the training, you will be able to write that exam, and you can find openings in institutes. Say, I've already told there is some openings as JRF, SRF in patent facilitation centers or patent litigation and other opportunities in private sector. If you know that act properly, you can come and uh, uh, be the agent, patent agent, all that. So, any other queries? So I think I'll go to a small quiz. I need you to answer this. Okay. Don't stay silent. Just say what you feel is right. Okay. So find some famous trademarks in this, please. Amul, yeah, correct. You can speak out also. Amul is there. Lux is there. Pepsi is there, correct. Thank you, Ashwati. Dettol. Cadbury is there, right? You're getting most of the things here. Now, anyone else want to try?
Link.
Tata Link. Yes, yes, yes. Thank you. Then anyone else? So I think most of the things you have told. So I think you told almost everything in this. I think Horlicks is something you missed out. Rest everything was told by one or the other. So the next one is you should find the IP that is related to each of these pictures. So the first picture is a painting, and can you tell me what is the IP that is related to this particular painting? How can you protect this particular painting? Through which IP? Through which IPR? Copyright. Thank you, Gayatri. Copyright. Now the second one. The second one is a sculpture. This can be protected via, I myself will be telling, designs, or it can be copyrighted also. The third one. Anyway, two you people missed. No reply from your side. The third one, you can see that Apple, MacBook, iPhone, iPod, etc. These will be protected under which intellectual property? Design. Okay. Okay. Then another thing. Something else is also there. Seeing the symbol word trademark. Thank you, Leo. Now the fourth one is this Bisleri. Bisleri is what? A patent for the display technology. Thank you. That is also there. And this Bisleri. Fourth one.
Trade name.
Yeah, trademark. Yes. Thank you, Gayatri, again. Then the next one, the bottle. Design. Design, yes. And what about that writing here? Trademark. Thank you, Aldo. So this is the various IPs. Now, okay. Now, and a question, MCQ kind. Which type of IP protects the painting painted by artists? Copyright. Thank you, Ashwati. Copyright. Now, Akila also told copyright. Nice. What protects the intellectual property created by fashion designers?
Design.
Design. Thank you. Leo also told design. Thank you. Design. Correct. What protects the advanced brake for bike developed by the inventors?
Patent.
Patent. Thank you. Patent. Yes, yes. Thank you. Now, next one. Which of these is a geographical indication? BMW, Nagpur Orange, Ironing Machine Custom, PlayStation, World Wide Web. Which of the following is a GI?
Nagpur Orange.
Thank you. Now, what does a trademark protect? It protects an invention or a work of art, logos, names, and brands, a secret formula.
Logos, names, and brands.
Thank you. Now, how long can a patent last? 10 years, 20 years, 40 years, 60 years? 20 years. Thank you. Many have answered that. If you write an original story, what type of intellectual property gives you the right to decide who can make and sell the copies of your work? Copyright, GI, patent, design, trademark. It's copyright. Many have told it. Thank you. Good. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? What will he use to show that the clothes are from his company? Trademark. Very nice. Trademark. Yes, yes. Many have answered trademark. Now, if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention?
Design.
Patent. Very good. Yes, it's patent. Now, that was the end of the quiz. Thank you for your patient listening. And if you have any queries, you can ask me. Or you can even mail that query to my email ID. I'll be replying you back if you get any query.